All right, today I'm sharing the 5 clauses that separate developers who survive lawsuits from those who don't. I'm Santiago Cueto, board certified international business law expert and best-selling author. I've defended dozens of developers in defect litigation. Now, a developer I know got sued for $3 million over foundation cracks that appeared 2 years after closing. The homeowner won. The reason? His contract was missing one simple clause that would have thrown the entire case out before it even got to trial. That single oversight cost him everything. Now look, construction defect claims are exploding in Florida. Buyers are getting more sophisticated. Their attorneys are getting more aggressive. And juries, they love siding with homeowners. Your insurance might cover some of it, but these cases drag on for years. They destroy your reputation, they tie up your capital, and they can personally bankrupt you even when you did quality work. The difference between winning and losing often comes down to what you put in your contracts before anyone signs it. All right, now the first clause is the notice and opportunity to cure provision. This one is non-negotiable. Florida law actually requires it in many cases, but most developers write it wrong. Here's what it needs to say. The buyer must notify you in writing of any alleged defect within a specific time frame. 30 days is standard. Then you get the right to inspect the property within another 15 days. After that, you have 60 days to either fix the defect or offer a cash settlement. The buyer cannot file a lawsuit until this entire process is complete. Why does this matter? Well, because most defect claims fall apart once you actually inspect them. That crack the buyer says is structural, it's often cosmetic settling. That leak they're claiming caused $50,000 in damages, usually it's from their own modifications. When you have the right to cure, you control the narrative. You get to bring your own experts in before the buyer's attorney does. You can often settle for pennies on the dollar, or you can discover the claim is completely bogus. And if it does go to court, you've created a paper trail showing you acted in good faith. The second clause is the express warranty with defined scope. Never leave your warranty vague. Vague warranties become whatever the buyer's attorney says they are in court. Your clause should specify exactly what you're warranting. Structural components? Well, let's list them. Foundation, load-bearing walls, roof structure. And time frame? 1 year for workmanship, 10 years for structural. Be specific. Then here's the critical part. State explicitly that this warranty is in lieu of all other warranties, express or implied, including the implied warranty of merchantability and fitness for a particular purpose. That last part excludes implied warranties. Florida law will read those into your contract unless you specifically disclaim them. And implied warranties are broad. They're subjective. They let juries decide what you should have done even if you never promised to do it. An express warranty with defined scope tells everyone exactly what you're responsible for, nothing more. So when a buyer sues claiming you breached some undefined standard of quality, you point to this clause and it stops the claim cold. If you're finding this valuable, do me a favor. Hit that like button right now and subscribe so you don't miss the next video. These clauses can save you millions of dollars. So let's keep going. Now, the third clause is the limitation of liability cap. This one makes buyers really nervous, but sophisticated developers never build without it. Here's how it works. You include language stating that your total liability for any claims arising from the contract, whether in contract, tort, or otherwise, shall not exceed a specific amount. That amount is typically the purchase price of the property. Some developers go lower, 10% of purchase price, or a flat dollar amount. So why is this powerful? Because without it, you're on the hook for whatever damages the buyer claims. Emotional distress, lost rental income, diminution of value, consequential damages that have nothing to do with actually fixing the defect. I've seen cases where the actual repair cost was $20,000, but the buyer claimed $300,000 in total damages. A liability cap cuts through all of that. It tells the jury that even if the buyer wins, this is the maximum amount they can recover. It changes the economics of the lawsuit. Many attorneys won't even take a case on contingency when there's a tight liability cap in place. The fourth clause is mandatory arbitration with a construction-savvy arbitrator. Now listen carefully to this one. Juries are terrible for developers. They're sympathetic to homeowners. They don't understand construction. They award damages based on emotion. Arbitration changes everything. You're putting your case in front of someone who actually knows the difference between a cosmetic crack and a structural issue. Someone who understands that settling happens, that materials expand, that Florida's climate is brutal on buildings, and your clause should require binding arbitration for all disputes. It should specify that the arbitrator must have at least 10 years of construction law experience. And discovery is where plaintiff's attorneys run up costs trying to force you into settlement. Limited discovery means that most cases move faster and cost less. And most importantly, arbitration keeps the dispute private. No public record, no newspaper articles scaring off your future buyers. When you go to arbitration, you control the battlefield. Now, the fifth clause is the attorney's fees provision with a prevailing party standard. Florida has a rule about attorney's fees. Generally, each side pays their own unless your contract says otherwise. You want a clause that says this. In the event of any dispute, the prevailing party shall be entitled to recover reasonable attorney's fees and costs from the non-prevailing party. This is your nuclear deterrent. You see, most defect claims are marginal. The actual damage is minimal, but the buyer's attorney is working on contingency. They have nothing to lose by rolling the dice. An attorney's fees clause changes that calculation completely. Now, if the buyer loses, they're personally on the hook for your legal bills. And defense costs in construction litigation, they run into six figures fast. This clause stops frivolous lawsuits before they even start. It forces buyers to think twice. And if you do win, you're not left holding a massive legal bill while the buyer walks away. Now, these 5 clauses won't prevent every lawsuit, but they will prevent most of them. And for the ones that do get filed, these clauses give you leverage. They cap your exposure, they control the process, they shift the economics in your favor. The developer I mentioned at the beginning, his contract had none of these. He learned the hard way. You don't have to. The contractors and developers who win are the ones who build protection into their contracts before problems arise. Don't wait until you're served with a lawsuit to wish you had better paperwork. If this video helped you, make sure to like it and subscribe to my channel. I post new legal strategies for business owners every single week. I'm Santiago Cueto, your Florida business attorney. Be sure to stay and watch more of my videos right here.